Hello, my name is Radosveta Vassileva. Unfortunately, I could not attend the conference this year, so I made a video for everyone who is interested in my topic. My article is dedicated to the evolution of hardship in Bulgarian, English and French law, and I argue that harmonization between these jurisdictions is impossible because of contextual factors. Why did I choose these jurisdictions? First of all, I have a personal interest in them. I'm Bulgarian, but I earned my law degrees in France and in England. And I always felt that one of the key aspects of my work was to bridge the gap in knowledge between East European jurisdictions and West European jurisdictions. And secondly, from the perspective of hardship, the dynamic between these three jurisdictions is really interesting from a comparative perspective. My article is divided into two parts. The first part is contextual and the second part is functional. I show that in similar circumstances it is very likely that France, Bulgaria and England reach different results, which is always important for a comparative study. Now I'm very thankful to UCL's library for helping me fetch a book from 1937, the conference proceedings of the International Week of Comparative Law in 1937, because this was a hugely important event at the time. One of the key topics that was discussed was hardship. And the event was attended by hundreds of scholars, and the viewpoints of 14 jurisdictions were presented. And at the end of the conference, they actually painted a spectrum, and they divided the responses into two groups: the non-interventionist camp, where they placed the Romanistic legal family, and the interventionist camp, where they placed the Germanic legal family. And they put England in the middle because of the doctrine of frustration, which was based on an implied condition at the time. And they said that basically this principle could be used to target instances of hardship. Now, looking back, it's really interesting that shortly after this spectrum shifted, so gradually Bulgaria moved to the far end of the interventionist spectrum. So as early as 1950, it enacted a principle on hardship, albeit with a limited scope. It said that where price in a manufacturing contract was agreed as a total sum, and there was a rise in the price of labor and materials after entry to contract, the price had to be modified. And in the 1990s, after Bulgaria was no longer a communist country, in 1996, Bulgaria enacted a general principle on hardship applicable to commercial and civil contracts. In France, the situation is rather different. This topic has always been, I would say, controversial. France enacted a general principle on hardship only in 2016 as Article 1195 of the Code Civil. Before that, there was a sharp divide between the approach to hardship in administrative contracts, where the judge could intervene, and the approach to hardship in civil contracts, where judges refused to intervene. And that is why historically French legislators have addressed these issues by enacting temporary statutes. So both after World War I and World War II, there were special statutes targeting specific agreements or specific types of hardship. Now in England, nothing has changed, in the sense that the doctrine of frustration has obviously evolved. Now the test is even harder to satisfy. So in Davis Contractors, it was established that circumstances need to become radically different from the time of entry for an agreement to become frustrated. So that is why it may not come as a surprise that so far there is no case law in which frustration was successfully applied to instances of hardship. At the same time, faithful to the principle of freedom of contract and sanctity of agreement, English judges encourage parties to include detailed force majeure hardship clauses, basically to determine the risk, distribute the risk, and determine the consequences of supervening events on the agreement by themselves. Now, From a historical perspective, there are several aspects which I find really interesting and intriguing. The first one is actually the interesting dynamic between a mother system and a daughter system. So initially, actually, Bulgaria had borrowed its law of obligations from France. And in the 19th century, at the end of the 19th century, in the early 20th century, Bulgarian scholars believed that the French model was viable and useful for Bulgaria. But shortly after World War I, they started attacking the rigidity of Code Civil, and they believed that it over-prioritized freedom of contract, and that the liberal individualist model embedded in it was already outdated. And so in my paper I have quite a few colorful quotations that the Code Civil is gone yellow, old-fashioned, inadequate to reality, and dry. It relies on dry formulations. So as I said, Bulgaria enacted a provision on hardship with a limited scope in 1950, when it was already a communist country. But one can find the seeds of this reform in the rhetoric from the interwar period. And another thing which I find fascinating is that they actually secretly borrowed this provision from Italy, which is also interesting. And I've written a paper on this, how we have a communist country allegedly borrowing doctrines and principles from a country with a rival ideology. Now, in France, there was a big debate on imprévision. Even today, scholars don't seem to fully agree on how useful this principle is and how compatible with French law. So it's rather interesting how in Bulgaria basically there was no debate. It was accepted as something necessary, and in France the debate still stands today. A second aspect from a historical perspective, which is interesting, is of course how the same event triggered very different responses. In the UK, I've discussed several cases in which judges refused to address supervening onerous performance because they argued that the ultimate value of the English legal system is commercial sensibility, and of course freedom of contract is important. So unless parties have agreed on modifications, terminations in the agreement, they just refuse to help. Now, in Bulgaria, judges are traditionally sympathetic to parties experiencing difficulties, and in France, at least scholars have raised concern, and especially the movement of contractual solidarity that emerged in the early 20th century was very active and endorsing such a principle. So in the second part of my article, I engage in a functional comparison to show that in singular circumstances, it is very likely that Bulgaria, England, and France reach different results. I thought it would be important to contrast the English response in Davis Contractors, the leading case on frustration, with the likely responses in Bulgaria and in France. In Davis Contractors, the House of Lords established the modern test of application of the doctrine of frustration, that circumstances should become radically different from the time of entry. And for those of you who are not aware of the facts of this case, basically it concerned a construction agreement. Davis Contractors had undertaken to construct 78 houses for 8 months at a fixed price. However, there were shortages of labor and materials, and a long period of frost, so performance was slowed down, and it was costlier. So I calculated actually it was 22% more expensive than planned initially. And the House of Lords actually said that circumstances were not radically different since the time of entry, and this was merely an imprudent bargain. Davis Contractors had assumed this risk that performance could become could become slightly costlier. Now, by virtue of Article 266, paragraph 2 of the Bulgarian loan obligations, this case actually would have had a very different result under Bulgarian law. I have the provision here with me. If in the course of the performance of the contract, the duly determined prices of materials or labor change, the compensation shall be adjusted accordingly, even where it was agreed upon as a total sum. What is important to emphasize is that this provision is applicable to manufacturing contracts only, but under Bulgarian law, construction contracts are manufacturing contracts because the definition is rather large, rather broad. Better to say. And in addition, what's interesting about this provision is that it doesn't stipulate a threshold of change. So any change in the price of labor and material should lead to modifying the price in the contract when if initially it was agreed upon as a total sum. And I found a recent case from 2013 where this provision was applied successfully to facts which are very similar to Davis contractors. So it's fascinating that we have two different responses to the same problem, and this is always fascinating from a comparative perspective. Now, how would a French court react? I think that from a French perspective, we have an interesting debate. I don't want to enter into much detail whether this is an administrative contract because one of the parties actually is a municipality, or whether this is a civil contract. But if you treat this as an administrative agreement, then the precedent set in Gaz de Bordeaux would be applicable. And in this case, the Conseil d'État in France was concerned about the rise in the price of input goods. So the price had increased 5 times. And to me, this seems like a significant change. So I doubt that a 22% change would be considered that significant. And if we consider that this is a civil agreement, then the key criteria in the new provision 1195 includes the foreseeability, the risk distribution, and also the excessiveness of the change. Now, would 22% be an excessive change for the French court? I actually doubt it. The second line of cases I examined concern Article 307 of Bulgaria's Law on Commerce, which was enacted in '96 in a period of monstrous inflation. So I have the provision here with me. A court may, upon request by one of the parties, modify or terminate the contract entirely or in part in the event of the occurrence of such circumstances which the parties could not and were not obliged to foresee, and should the preservation of the contract be contrary to fairness and good faith. Now, from the standpoint of interventionist jurisdictions, this provision is not that unusual, but still you can identify, for instance, some key differences between the French new Article 1195 and Bulgaria's provision. So here, the legislator did not encourage parties to negotiate before they make the request before the court. In addition, the provision encourages a unilateral decision by one of the parties rather than both of them submitting a common request. And we also have a strong emphasis on fairness and good faith. And I don't have the time, obviously, to enter into too much detail about the criteria of application of Article 307, but this criterion seems to be one of the most important ones. As a result of an external event, performance becomes contrary to fairness and good faith. And for Bulgarian courts, this means lack of equivalence of obligations, lack of equivalence of performance. I give more than I receive. And it's really interesting that Bulgarian doctrine often argues that this equivalence is subjective, but Bulgarian case law demonstrates that many courts actually interpret this requirement literally. So I've discovered 2 cases in which Article 307 was successfully applied. Both of them are recent, and they concern similar facts. Both of them involve long-term lease agreements entered into at the beginning of 2007. To almost 2 years after entering into an agreement, the lessees, both of them separately, argued hardship, and they demanded termination before the court. And in both cases, the court was sympathetic to the aggrieved parties. So the judges were particularly troubled by the fact that the revenue they made, the lessees made, was lower than the rent, and they declared that this was the result of a global financial crisis. Therefore, they terminated the agreements. And I find this fascinating because, if you remember, in those days, a hot topic was the subprime crisis, but it never really hit Bulgaria. So I find it difficult to even establish what financial crisis the judges established. I went to the National Institute of Statistics to gather some information, and it turned out that in 2006, yearly inflation in Bulgaria was estimated at 6.5%, and then in 2007, the yearly inflation was estimated at 12.5%, and I guess this is the moment when the lessees started experiencing difficulties, but the inflationary change is just 6%. So moreover, in both cases, the lessors tried to renegotiate the lease agreements, and they proposed reductions of 20%. And not only the lessee didn't accept these proposals, but the court didn't consider that these proposals were adequate to the situation, which is quite interesting. Now, from an English perspective, I believe that these cases would have had a completely different result. I think it's really difficult, borderline impossible, to argue frustration because circumstances have not become radically different from the times of entry. It's difficult to argue that the lessees have to perform something that they haven't promised. The only case in which I've discovered that English judges showed concern about rampant inflation was Staffordshire Health Authority. However, it was decided by Lord Denning. It concerned a 50-year agreement, so after 50 years, difficulties were experienced, and then he was concerned about inflation in the span of 16% to 24% per year, so it's really substantial. With regard to French law, I think that once again it would be difficult to apply Article 1195. As I mentioned earlier, the key criteria include foreseeability, lack of, this change hasn't been assumed as risk, and then the change should be excessive. Now, is a 6% inflationary change excessive? And was it not assumed as risk? And I didn't mention this earlier, but one of the agreements actually contained a clause for early termination against the compensation. So I guess for many West European judges, this would mean a clear distribution of risk. They had the option to terminate the lease. It's just that it was more expensive, so it was basically a bad bargain. Now, to conclude, I believe I've showed you that there are important differences between France, England, and Bulgaria in practice. Moreover, I believe that I've showed you that these disparities have appeared because of contextual factors. So Bulgarian scholars and Bulgarian judges have simply become more sensitive to substantive fairness and social justice in contract law, and communism certainly played a role. At the end of the day, it's also very difficult to teach, for instance, senior judges who have earned their education during communism how to think like a West European judge. So obviously communism has left a permanent mark on Bulgaria's legal culture. Yes, that is why I argue that harmonization between these three jurisdictions, at least on the question of hardship, is impossible at this stage. Thank you very much for your attention, and if you're interested in my paper, I'll be happy to share it with you.